All right, welcome back to day number 2 of the state laws of the fun day. We are going to pick up there on letter L, acts of a commercial broker, out-of-state commercial broker. All right, they specifically mentioned commercial broker in this, but it kind of works for residential as well. And this sort of makes sense if you think about it. There are, number 1, commercial broker licensed in another state, but not Indiana, may perform acts typically requiring a license with respect to commercial real estate within this state, provided they do the following. Now, this makes sense. So what they're talking about is a Florida license is going to work in Indiana, but he doesn't have an Indiana license. He can do that. It's called through reciprocity. We can do it too. As long as you do these things. Number 1, you must cooperate and have a written agreement with the broker here in Indiana. You will comply with all our Indiana laws. You will use or deposit all the money into escrow funds with the Indiana broker. You have to provide the Indiana broker with proof that you have a Florida license. Number 4 says you file what's called an irrevocable consent to suit. What an irrevocable consent to suit is this. Let's say I lived in Florida, come up to Indiana to do some business, and I did something wrong, and now I'm going to run to Florida and hide and just say, I'll never come back to Indiana. No, irrevocable means you can't take it back. Consent to suit means I'm agreeing to a lawsuit. So you would have to come back up and face the music. You can't run and hide. That's what they are required to file an irrevocable consent to suit. And number 5 says they can practice in the state as long as they're all met. So that makes sense. Think about what I just said. Florida guy wants to do some business in Indiana. He's not licensed here. He can work under an Indiana broker up here as long as he goes by Indiana laws, uses the Indiana banks, works underneath an Indiana broker, files the irrevocable consent to suit. So that makes sense, doesn't it? If he's going to work up here, he uses these laws, these banks, all of that. That's what they're saying. Only applies to commercial real estate brokers. This law only applies to a commercial real estate broker doing commercial business. Letter M, you can only associate with one managing broker. I told you that. You can't be a carpenter during the week and have a part-time gig as a RE/MAX agent or a weekend gig. You have to maintain evidence of licensure in the office. Now, we have outpaced our own laws. Technology has outpaced our laws. This is a great example of one. This law is still on the book, but it allows the internet to do this in its place. And I told you, we used to have the wall up on the wall. Now someone comes in and challenges me. I can look up on the internet, providing my internet's working, which it's not right now, and prove that you're licensed with me, okay? You must advertise only in the name of your managing broker or broker company. So when you start advertising, you will put blah, 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 blah of the Modular Group or Carpenter. You've got to make sure that they know that you're an agent and you're advertising for that you are a licensed agent and a broker. You cannot maintain an office apart from one provided by the managing broker. When you become an agent of, say, Southside Carpenter, they're on County Line Road, that will be your legal office address. All your mail will get sent to there and all of that. Even though you think you work out of your home, or some of us think we work out of our car anymore as we drive around, your office will actually be where you are assigned to, and that will be your office, okay? If you terminate with a broker, letter N, here's another example of technology has outpaced our ability to change laws. Upon termination of the brokerage, all of your listings and buyers turn back over to your managing broker, okay? Your listings are not your listings. Whose are they? Mine. You guys Seen Finding Nemo? Remember the pelicans? Mine? Mine? All your listings are mine. Your clients are mine. The commission's mine. It's all mine. It's not yours. So when you leave the Modulin Group or whoever you leave, your listings stay with the company, and so do all your buyers. Okay? If you want to move, it is your responsibility to enact the proper procedures. You want to leave, Carpenter? You have to do the work. You don't call me and go, hey, can you sign a release? No. You want to leave? You sign it. You work it out.
So if a client calls you specifically, like they have your private number and you say, oh, I'm not with Ray's group anymore,
Yeah,
I
can't even talk to him. Matter of fact, if I find out you talk to him, that's a violation. That's one of the confusing things that people think. Well, I'm going to quit the Modulin Group and I'll go call my clients and tell them I left. No, you won't, because the second you quit me, A, you don't have a license affiliated with a broker. You're not actively licensed. And B, if you're talking to my client, that's a violation. So you would just disappear from them. All right? Managing brokers can move an affiliated licensee to the state at will. I have done this before with one of my own agents. They were violating rules. We had a discussion. He told me what I thought I should do to myself, and I literally picked up the phone and said, I am moving Steve's license to referral immediately, or back to the state in referral. He's like, you can't do that. Yes, I can, because you're my license. If I don't want the responsibility, I can move. I don't even have to call you. I just move your license back to the state. All right? Now it can be done online. Used to be we had this thing about 5 days. You had 5 days. If you left me, you had to put your license somewhere else for 5 days. You might want to write that in there. I don't know if that state still gets on that. So in other words, here's the old days. In the old days, Min worked for me. Then he and I got sideways, so he decides he wants to leave. He would have to go get the form, come to me and say, I'm leaving the Modulin Group. I want to go to RE/MAX. He would have to get me to sign the form. He now has 5 days to get that form signed by someone else because he's not out there. He can't be his own broker yet. So he's just kind of floating around. He's got to go get it signed by Paul Caldwell out at RE/MAX, who Paul's not there anymore. He sold that. But he would then get issued a new license in the name of the new broker. All right? And that would all be your agent's responsibility to do that. So it used to be 5 days. Now with technology, and that 5-day law is still on the books, by the way. But with technology, it's done like this. Men wakes up one morning at 6 a.m., goes to the computer and goes, leaving the Modulin Group, going to Tucker. Sends an email. I get an email and go, do I accept that? Yes, I accept it. Tucker goes, I accept it. Boom, his license is transferred. All right? So the law of 5 days is still on the books, but our technology now, we don't even have a form. He can sit in his underwear at midnight and do the whole thing via email. All right? Non-residents of Indiana can be licensed, but they can only serve as a broker, meaning they cannot have their own company here and be a managing broker. Why is this rule important? Do what? Think about all of those cities like Jeffersonville and Richmond and Maryville, where they're right on the border, where you might have a Kentucky agent come across the river to sell a house on this side of the river, which is Indiana. So they can get an Indiana license. All right? They just can't start their own company in Indiana because they're not a resident of Indiana. Same thing. Non-residents shall file the irrevocable consent to suit. If we have reciprocity with them, then they have to follow our license law. And non-residents also have to apply with our CE rules. So if you're licensed in another state, Dusty, you may do 12 hours in Indiana every year, but you may also have 12 hours for Florida's requirement. So you end up doing 24 hours, 12 for Indiana, 12 for Florida. All right? What you hope is to find a school that has a course that may be dual licensed. Some of ours are licensed in Kentucky for that very reason. So a person can take a 2-hour course and it counts as 2 hours for Kentucky and 2 hours for Indiana with only one course. All right. Letter P is interesting. Death of a sole proprietor broker. If, let's say for this example, you guys all work for me. You're all members of my brokerage. I'm the managing broker. If I die, you have all your listings out there, and some of you got some deals that are pending to close and all of that, right? You have 90 days from the day I die to finish all of your deals. So everything that's pended has to finish, right? Everything that's pended has to finish. All of the listings that you have go away. All right? Everybody understand the difference between a pending and a listing? A listing is when you put it on the property and you're marketing it for sale. When you get a contract between a buyer and a seller, it goes to pended, right? Once it's pended, you have 90 days to close it and earn money. All of the ones that are actively listed go away. And number two, the commission will come in and take over my escrow account to make sure that you guys get the earnest money that we have collected for those pended deals. Okay? Number three is a very funny one. Number three says that you guys can open an earnest money account in the timely event of you have received the earnest money, I die before you get back to the office with the check. I mean, there's a slight sliver of time in there. Yeah. It's had to happen, otherwise there wasn't a law. So what I'm saying is, you listed a property up on the north side, or you accepted the offer, you went up and picked up the earnest money check, you're on your way back to the office. When you get here, you say, well, Raymond got hit by what? He's dead? I've got an earnest money check in my hand. How do I put it into the bank with he being dead? That would be a case of where you could go out and make one earnest account deal because you've already pended the deal, but Raymond died before I could get back to the office. All right? During this 90-day period, you can affiliate with a new broker. Matter of fact, you must. So Raymond's dead. My listing went away. I'm going to go work over there at Tucker. Now you would go back to that person and say, hey, take the Modulin sign and just throw it in the dump because he's dead. Here's the new Tucker sign, and we got to sign a new listing.
Now can those clients call you?
Yeah. Yes, they can at that particular point. So any new business that you undertake has to be under a new broker that you have went and affiliated with. If you have the ability to become your own managing broker, and let's say you haven't done it, you've been in 2 years, you've taken the course, you just haven't done it, I die, the state will make you your own managing broker company. Unless you specifically go in and go, no, I don't want mine, I'm moving over to there. Then you got to go tell the state that. Yeah. They have the responsibility of sending the commission a properly completed transfer, and at such time you will be deemed in unassigned status if you don't. Number 6 is the fun one. Number 6 says, just because I died doesn't mean I don't get my share of the cut. All right? So on those pended deals, let's say we're 50-50 because that's easy to understand. Even though I'm dead, I still get my 50% because it will go into the business or the estate, which will go to my children or whomever deemed. You can't say, well, Raymond's dead. Do I get all 100% now? No. Just I died. I still get my ownership rights. Okay? Cool?